Dr. Lordship. Huh? My senior is out of station, Lordship. Out of station? Yes.
13th.
Lordship. 13th? Tomorrow?
No, sorry, but on 19th.
9th. Many matters have already been fixed. I think 20 something. 20. 20. CTV team. We are retaining the case diary till next date. Obliged.
May I please? Item number 4, motion matter. I may be allowed to withdraw this.
4. You want to withdraw this?
Yes, yes. It's my instruction.
Heard Mr. T. Gogol, the learned counsel for the petition, as per instructions. Also heard Mr. T. Gogol. Instructions. Yes. Then he wants to withdraw this in prayer allowed. Raise accordingly disposed of.
Okay, please.
May I please, Your Lordship? I'd like to match item number 27, 28, 29, Your Lordship. The engaged counsel Jed Alam's elder brothers expired, Your Lordship, some few days back, Your Lordship. Today there is some religious ceremony, Your Lordship. That's why he's not in a position to appear before Lordship today.
27, 28, 29, 30.
Yes, Your Lordship. We are for 27, 28, 29, Your Lordship.
30 is also connected matter.
Yes,
We all are for from 2014.
Yes, Your Lordship.
What is your problem, Mani?
Your Lordship, the engaged counsel Jed Alam's elder brother expired, Your Lordship. Today there is some religious ceremony, Your Lordship. That's why he's not in a position to.
Father expired.
Elder brother, Your Lordship. After 2 weeks, Your Lordship.
30 who is appearing, Mr. T.N. Das as Das.
Toilet.
Say 30 is order pass going then.
Okay.
It an approve 29 cool. In a connected matter also. Then I like certain put him again. Data 27, 20, 29. RMS as Nazin did an counsel for the applicant. And with consent of the other she paid final document stating that the engaged counsel, Mr. J. Alam, is in bereavement. Leads the matter accordingly after 2 weeks as an edit. Okay.
Obliged.
May I please, Your Lordship? Lordship, I'd like to mention item number 16 and 17. Chief Parat CD is not available. 16 and 17.
Case diary not received. You are on interim
Lordship.
in both the matters?
Lordship.
Oh, acha, acha. Okay. Yes, just tell us TS number.
Case number 35/26, dated 13/2/26.
So, okay, we are extending your interim for 15 days. Appear before the learned trial court below with an appropriate application for bail.
Obliged, Lordship.
May I please, Lord? Regarding item.
No, with here, second. Same, after same FI, isn't it? Same perfect.
Regarding item number 13, I'm told case diary is not available.
1-3.
1-3, ma'am. There's an interim order, ma'am. Which case?
Interim was there.
Interim is there, madam.
City not received this reminder. Yes, but
He is already on 7th of April.
7th of April. Interim be continued till next date of listing.
I'm deep aware.
I'd like to mention item number 15, madam.
1-5.
1-5, madam. CD possibly not here. Yes, yes, right.
15 my lord in the city of
Date may be fixed, madam.
You are on interim? No.
I'm on interim,
You
madam.
are on interim.
Interim.
docket submit.
Oh, acha, acha. Yes, tell us this asset number.
Docket number 137/25, dated 15/12/20.
Okay, then we are extending your interim for 15 days.
My lord.
Appear before the learned trial court below with an appropriate application for bail.
Obliged. May I please, your lordship? Lordship, I beg to mention item number 18, madam. Kindly this matter will be adjourned for the day, my lord. Next day, any date, my lord.
15 case diary repeat.
Yes, there is. We have some problem to do.
My lord, engaged counsel is out of state.
Mr. S.M. Abdullah.
Yes, madam.
Yes, and this counsel is out of station. Going to go. CD, you're going to retain the case diary?
Lucky may not
Okay, then we'll fix it on
Fix it on
22. 22 is the working day.
20.
20. Watch. 20 question. CDT return to take around Nalaya because she will talk to.
Well, there is an interim, madam. Valid, madam.
Interim will continue.
I won't
Interim will continue the next day.
May it please, Your Lordship. Lordship, regarding item number 22, Your Lordship, the matter has become infractuous, Your Lordship.
22.
Yes, Lordship.
Yes. How?
We have got the street hunt and everything. That's why we don't want to continue the thing.
No, don't want to continue here or don't want
Yes, we have got instructions from the client. They have received the street hunt. They have.
receive this street hunt will not become infructuous for receiving back this street hunt will not become infructuous for this present petition. Because present petition, most probably there is some order against that order you have come. It is a
Yes, sir.
revision, isn't it? So if you say that you don't want to praise the petition as per your client's instruction, then it can be disposed of on withdrawal. But infructuous, we cannot write it infructuous.
Okay, then.
Okay.
Yeah, we have got
Your
instructions.
good name?
B. Soren.
Hard MSB Soren, they learn it. Your name is not reflected here.
Yes, Your Lordship. I'm on behalf of BD Core, Lordship.
BD
Yes,
Kaur,
Learned Senior Counsel.
appearing on behalf of Mr. BD Kaur, they learn it submitted as per the instructions of a client. She already received back all her student items, doesn't want to proceed with the present petition further in view of it, and accordingly want to withdraw this. Considering the submission made by the counsel for the petitioner, matter is withdrawn. No, matter is disposed of on withdrawal.
Apply.
Wait, please, Your Lordship, I beg to mention item number supply list 43 and 44, Lordship. Kindly pass over the matter for the day, Lordship.
Just a second. 43 and
20.
are they on interim?
44.
43 and 44? Was there any interim?
No, my lord, interim was
44.
yes, my one report was earlier called for, my lord. In many occasions, in item number 33, no one appeared, my lord, from the date of filing of the case, my lord.
No, we are saying on 43.
43, yes, 43, my lord. Today only they have appeared, my lord. Since the date of filing of the case, no, till date, no
Oh.
one appeared, my lord.
Oh,
For non-appearance, in case of non-appearance, on next date, appropriate order will be passed. So, my lord, any date, my lord, on 26th of March, my lord.
you are MS?
A. Mohanta.
Hard MS A. Mahanta, the learned counsel for the petitioner. Hard Mr. P. Bot, the learned petition PP appearing on behalf of state. It is submitted by Mr. Portable that is the date of filing. The petitioner remain absent. And today is the first day when they appeared. In view of this, let the CDB call for issue. CDB call for list the matter accordingly. When it can be listed?
On 26th, my lord.
26-3. And what about the 44?
44 also, my lord, on same date, same.
You have not received the case diary here?
No, my lord, here also report one.
They are saying that they are in interim in that case. Is
Yes,
it? Interim is there.
interim.
Interim to continue reading. We are listing both the matters of 26.
Months.
My lord, regarding item 11, Your Lordship, city not come, Your Lordship. I am on interim order, Your Lordship. Success,
You are on interim?
yeah. Success is already submitted in the case, Your Lordship. Co-accused already released on bail, yes.
No, whatever. You are on interim.
Interim. Success submitted.
Charge is submitted.
Started submitted, my lord.
In that case, we have to pay the ticket.
Yes, scan copy of this here maybe.
You are MS?
Your Lordship.
You are MS. Good name?
A. Begum.
Hard MS A. Beckham, the learned counsel for the petitioner. Also heard Mr. P. Waterpool, the learned edition PPA payment. It is submitted by Mr. Waterpool as well as Mr. Begum, MS Begum, that case has already been charged. She submitted that the petitioners are in interim bill, interim bill, and the in view of this, let this scan copy of the TCI along with the case diary be called for from the Don't know from where board, which
Uh,
board it has to account for now.
From, yes,
Pendency to we cannot say now.
from the CJM Lokhimpur,
CGM Lakhimpur.
Lokhimpur.
CGM Lakhimpur.
CS number 1/26 dated 10/1/26.
CS number 1/26
dated 10/1/26.
10/1. Is diary and scan copy picture is type of available. Interim be continued till next date of listing. We're listing it on 2nd of April.
Yes, ma'am.
Okay.
Please, the Lordship, I seek permission for urgent listing the criminal revision petition.
Make a mention before court number 8.
May I please, Lordship? Actually, I beg to mention item number 8. Kindly adjourn for the day, Lordship.
You're for the petitioner.
Yeah, yes, Lord.
You're appealing for whom? P.V. Bora.
B.B. Bora, Lord.
And your good name?
J. Gogoi, Lordship.
Her name is J. Gogoi, appearing on behalf of Mr. P.V.
Interim
Bora
order continue, Lordship.
for the petitioner. Accordingly, paid for an adjournment. The day prayer allowed. List the matter accordingly. Your interim was there.
Yes, Lord.
Interim be continued till next date of listing. List account. Okay. Adjourn for the day. Rest you will as on a date to feel very rest. This criminal petition for quashing stands dismissed. Check for years ago.
May I please, Lordship? My Lord, this is a regular bill application. Lordship will find at page 9 is the my Lord affair. We are not named in the my Lord affair. Page 9, my Lord.
Yes, page 9.
Yes.
Hmm.
May I read, my Lord?
Ah.
I have the honor to state that my son, so and so, went to religious meeting on 16/2/2025 at about 7:30 p.m. Later on, I went to the said religious meeting with my minor children. And at night, about 1 a.m., I returned back with my minor girl to my residence. But Ramzan Ali was not found in the house. Though his mobile phone was seen, but no SIM card was available in the mobile. I suspect that since there is no charge in the mobile, he took the SIM card from the mobile. Last on 17/12/2025 in the morning at about 6 a.m., my brother-in-law so found the dead body of Ramzan Ali in the jungle while he was going to see the cultivation from the backside of the house. And having seen the dead body, he started crying, and having heard the crying, we reached there and saw the dead body. The face and various parts of the body of the boy were found to be injured. It is suspected that my son might have been killed by some unknown person and thrown away in the jungle backside of the garden. That is the affair. Now, Lordship, kindly see the forwarding report. Forwarding report.
Page 21.
Yes. Page 21 is the forwarding report. Now, as on date, 49 days in custody, and in the arrest memo, Lordship will find there is no ground has been mentioned. We have obtained the certified copy malad subsequently malad, so we could not annex malad. Column number 2, man. Workshop will find column number 10. Region, stroke malad ground of arrest. Second. So malad in view of the malad Mihir Rajesh Shah case malad, the entire malad detention period is illegal. And considering that malad situation, malad the DK Basu case and malad Bihan Kumar case, they are entitled to be released on malad regular bail. This is the malad latest judgment of the apex court, saying that malad discussing the DK Basu and malad Bihan Kumar, etc. Yes.
Yes. In which para you are
Paragraph
emphasizing?
56, malad.
It's para 56.
56.
This is the arrest memo, my lord, not section 47 and 48 notice. The forwarding report, detailed grounds of arrest is there.
Now see, Mihir Rajesh is completely on 47, 48 corresponding to 50, 50 CRPC.
Yes.
It's not about this arrest memo. You are on arrest memo, basically you're emphasizing on arrest memo.
Yes, arrest memo.
Mihir Rajesh doesn't say so.
Right.
It is completely on 47, 48 or 50, 50
Yes.
ACR.
That is there.
Hmm.
Malad, since malad we are not named in the malad affair and reason is not there in the arrest memo. And moreover, malad 49 days in malad custody, considering the detention period also.
Young boy, you have killed a young boy, isn't it?
Yes, young boy.
Then what to do?
That is there. Malad.
There are PO Lordship may kindly produce forwarding report. Forwarding report, well, from the forwarding report,
Yes.
during investigation.
Hmm.
And otherwise, in the forwarding report itself stated that 47, 48 notice served. And this is the, so at this stage, case diary may be called for to find out whether those grounds of arrest are there in 47 and 48.
And even if I have seen the arrest memo which he has provided now. Basically, there are 2, 3 instances. There are many now. Now it is rising under 30. 6.3 as per 3060 witnesses signature has to be there, this and that. So here the witness signatures is also there.
Yes, yes.
It's
Signature is
available.
there.
It cannot be said that there is a total non-compliance of 3060.
Yes.
Anyway, when it can be. See,
Short date may be given. Malad. In that case, malad, short date may kindly be given.
we don't have any short date.
Depot date. 23rd of March.
Even five. Okay, then, 23rd.
Can
We
it
give
be
it
on,
short date.
can it be on malad 20th?
Not possible. City will not reach.
Today is 1.
Borrowed.
Today is 12. 20 malad cannot be possible. Malad. Because the festival is malad coming malad.
Okay, we'll try that.
Malad 20. Development.
Here স্যারটা আমার লগত করে দিব আমার লগত করে দিব
Yeah, please, Your Lordship.
Yes.
Lordship, another connected matter, Lordship, same affair, Lordship, fixed on 16, Lordship, 16-3, Lordship.
Okay, can
Lordship.
you tell us the number?
Lordship, CD may call for
No, can you tell us the number of that
Situation.
other BA?
BA number 684 2026.
684
684,
26.
Lordship,
It is fixed on 16th.
16, Lordship. Lordship, CD may
CDB call for,
call for.
CDB call for. Please the matter on 16/3/2026 along with BA number 684 of it. Okay, well, let's see it.
Your Lordship, arising from the same FIR, Your Lordship, another case is listed today before Your Lordship as item number 38, Your Lordship. CD has
38.
Yes, Your Lordship. Kindly this matter and That matter may be taken up together, Your Lordship. CGS
This
has-
matter may kindly taken up along with 38.
Okay, then pass 38. Huh?
Yes, Your Lordship. Obliged.
May I be your lordship?
Yes.
Repeating on the 482, my lord. Lordship, kindly see FIR at page 12, my lord. May I read, my lord?
Yes.
There are two accused persons, my lord. One Shukur Ali, second Mini Begum, wife of the Shukur Ali, my lord. Lordship, with due respect, I beg to state that the above mentioned accused person is having a grocery shop situated near the road in front of our house. The accused persons used to throw their garbage inside the boundary of our house. Although my wife Anwara Begum requested them to throw the garbage to some other place, but they did not comply to our request during my absence. They quarreled my wife with regard to the matter. On the last 10 to 25 at 10 a.m. in the morning, the accused persons thrown their shop garbage in the boundary of my house. When my wife came out from the room, found that garbage lying in the courtyard and on the house. As such, she raised objection for which the accused persons attacked my wife with a bamboo piece on her leg and her back. As a result, she fell down on the ground and accused number one pulled her hair, the hair of my wife, and after hearing the hue and cry, while my son Ismail and Ansari came age over 15 years to say to my wife, the accused person was Shukur Ali. He could try to kill him. When I reached the place of occurrence, then the accused person hit my neck and bamboo piece. With the help of neighboring, I took my wife and son and admitted to Barwala Hospital. So, Lordship, all allegations against the accused number one, my lord. And he was arrested, my lord. And the accused number two is the wife of the accused number one, my lord. And section, Lordship, all sections are available except 109, my lord. Even though, Lordship, there is no attempt of murder, my lord. And whatever allegation against the accused number one, so, Lordship, I am praying for Lordship one opportunity, my lord. She will appear before the Lange court below, my lord. That is, Lordship, matter is the session triable, my lord.
Laili Begum mean?
Yes, my lord.
Summons issued.
Lordship,
Charged case, my lord. He is
Oh,
shown
it
as
is
abscond.
fascinated case.
Charged case. He is shown as
I have
absconder.
next, my lord, similar order, my lord.
Summons issued in
It's page 28, my lord. Lordship, kindly see. The next date is my lord 6/4, my lord. 6 April, my lord. Then he is the wife, my lord. And he never, Lordship, participated this quarrel, my lord. Only the wife of, as the wife, my lord, he implicated. And all allegation against the accused number one, my lord.
She will obviously participate when her
It's a
husband
lady,
is
my
there with the garbage and all.
Lady, my lord.
Heard Mr. J.U. and M. Learned counsel for the petitioner. And also heard Mr. P. Bott, Learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Next part is submitted by Mr. Lashkar that the present accused petitioner is innocent and there is no specific allegation brought against her in the FIR. So, as the wife of the accused number one, her name is mentioned in the FIR. During the investigation, the police never searched for him, and hence she was not aware about the case instituted against her. However, the case has already been charged, showing her as an absconder in the showing her as an absconder. She already received a summons from the court, and also ready to appear before the learned trial court below and to contest the case accordingly. However, as she has been shown as an absconder, an interim protection may be provided to her so that she can appear before the learned trial court below. Next part, Mr. Botakur, the learned additional PP submitted in this regard that the petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with. He further submitted that till date only summons issued against the present petition. Next one, considering this submission made by learned counsel for both sides. The petitioner is hereby directed to appear before the learned trial court below within 15 days from the date of order with an appropriate application for bail, which may be considered in accordance with. However, till 15 days from the date of order, as an interim protection, no coercive action shall be taken against the present petition. With the above observation, the present AB stands disposed.
Problem. Madam, there's a pre-arrest bail application, my lord, FIRS page number 9. My married,
Yes.
page number 9. That married.
Yes, yes.
The informant begs to state that since last 10/10/22, the above named accused person, after knowing me, had promised me to marry me as he loves me. On last 5/4/25, the accused person took me to Gauhati by falsely saying that he would marry me and establish physical relationship with me for about 3 months by keeping me in a rented room at Ambari, Gauhati. Later on 25/5/25, he got transferred to Jirkiding police station, West Karbi Anglong, and kept me in the quarter of Jirkiding police station for about 7 months, where he cohabited and established physical relationship with me, and thereafter, whenever I used to ask him to get married or solemnize marriage, court marriage, the accused used to threaten and assault me in the quarter of police station. And the accused person injured me by assaulting me on last 6/9/25 at about 2 p.m. and 8:30 p.m. in the night. On 19/9/25 at 12, he broke the door of my room and injured me by assaulting. On last 29/9/25, the family members of the accused person came and verbally abused me by using bad languages and destroyed the article of my room, and the accused has also assaulted me. So this is the FIR, my lord, and the only non-bailable section is section 69, my lord, that having physical relation with deceitful mean, my lord. So what happened actually, my lord? At the relevant point of time, no FIR was lost, my lord. And I am from Karbi community and she is from Boro community. And in our Karbi community, there is no formal marriage is performed, my lord. Only we have to inform both the families that from today onwards, we are going to be living together as husband and wife. And we have did that, my lord. And accordingly, FIR itself says that near about 1 month, 1 year, my lord, she was with me. And I have not kept her hiding anywhere, my lord. In my official quarter, my lord, I have kept her. I'm a sub-inspector, my lord. And sir, only grievance is that she want to have a ceremony in Boro rituals. Then I have assured her that I will perform it, but due to my frequent transfer, my lord, I was unable to do. And kindly come to page number 18, my lord. Again, I was transferred on 1/3/26, my lord, from West Karbi Anglong to South Salmara, my lord. And I have informed her that I have again got transferred, my lord. And on that day, my lord, 1/3/26, this FIR has been lost, my lord. Kindly protect me, my lord.
Yes, but
Regarding injury and assault, only CD will reveal regarding that only injury report.
but it seems that she was with him,
Yes.
as Mr. Ali
Yes,
has
with
said,
him in
for
the
about
police quarter.
1 year, and
Yes.
that too in his official residence,
In
matter,
official
official quarter.
quarter.
It's not a case that somewhere they were there.
Yes.
Heard Mr. Chali, the learned counsel for the petitioner, also heard Mr. P. Waterford, the learned additional PP appearing on behalf of state respondents in application section so and so in connection with so and so. Considering the submission made by learned counsel for the petitioner, and also considering the statement made in the FIR, this court is of opinion that this is a bit case wherein an interim protection can be provided to the present petitioner so that he can appear before the IO and can cooperate in the investigation. However, Mr. Waterford raised objection and submitted that CD may be called to know the actual fact of the case. Okay, you'll be under interim protection. appear before the IO, but where the case is lodged in which place?
Khairoli, my lord,
police
West
station.
Karbi Anglong.
West Karbi Anglong.
Right.
And now you got transferred to.
South Sal, my lord.
So 7 days, within 7 days, will you be able to?
My lord, can leave,
10
can it be
days?
10 days?
Okay, we are giving you 10 days. Yes.
For 9th of April, 9th.
Obliged.
There, please, your lordship.
Yes.
Lordship 482 application, Lordship. Allegations are under section 115 to 89 and 35 of BNS Act, Lordship. Lordship, in this matter, the petitioner number 1 is a teacher by profession, and petitioner number 2 is a family member of petitioner number 1, Lordship. Here the FIR was lodged by the wife of the Lordship. FIR was lodged by the daughter-in-law of the petitioner number 1, Lordship. And the allegation is that, Lordship, page number 9, Lordship, FIR. Allegation is that humble submission is that on 21/1/2006, page number 9, Lordship.
Yes, yes.
At about 4:30 p.m., I came to my matrimonial house in presence of my husband to bring some articles, and I was not allowed to enter the house. Hence, my husband called me inside the house. Then the mother, father, and Safia Khatun assaulted me and my husband. I sustained injury in my stomach. I was 2 months pregnant at that time. As such, I was bleeding, and my child was damaged. This is the FIR, Lordship. Lordship, here the informant is the first wife of petitioner number 1's son. And on the day of incident, Lordship, on the day of incident, there was an altercation between the petitioner's son and his 2 wives, Lordship. There, this petition,
She is
yes,
first
Lordship.
wife. Who is the second wife?
This is the
Second
this is
wife
the
is-
first wife, Lordship.
She
And
is the
their
first
son-
wife. Who is the second wife?
Yes, Lordship.
Who is the second wife?
Second wife, Lordship, Safia Khatun.
Oh, Safia. She is second wife.
Accused number 3 of the first FIR, Lordship. And these petitioner number 1 and 2, Lordship, they are not involved in this incident, Lordship. The altercation between the husband and 2 wives, Lordship. That is, the husband is the petitioner number 1's son, Lordship. They are aged person, Lordship, and they are not
So
involved.
she has not
Lordship.
lost the case against her husband.
Yes, Lordship. First wife has lodged the FIR against her mother-in-law and 1 family member, and second against the second wife, Lordship. Lordship,
In allegation, her child got aborted. That
Yes.
is,
no, Lordship.
huh? No. As per allegation, yes.
And petitioner number 1 is a teacher, Lordship. And they are not involved. The quarrel was between their son and wives, Lordship, 2 wives. And hence another FIR was also lodged by the accused number 3, Lordship.
That is the only non-billable, that is the miscarriage.
Yes.
89.
Yes.
Obviously, if there is 2 wives, then
Second wife also made same kind of allegation, my lord. At that point of time, she was also pregnant, my lord.
And
Oh, where is the second
The
wife?
second wife, Sophia Khatun, has also lost one affair. That is,
FIR against
Sophia
her
Khatun
husband,
also.
Lordship.
yes, against her husband, my lord.
Only husband, Lordship, not mother-in-law or others. So there was,
Oh, where is her FIR? Here only.
yes,
Yes,
Lordship. I have annexed it, page number 15,
15.
Lordship, annexer 2.
And in
Oh.
this affair, she is an accused informant. Sophia Khatun is an
Is an accused.
accused.
And in that case also her
In her affair also, she stated that
acha.
she was at that point of time pregnant, and my lord,
Incident was occurred on the same day, but second FIR was
And second
registered
FIR,
on,
she made her husband the accused,
yes,
not this present informant. Where is the present?
not this second affair, my lord. It is
No. In second FIR lodged by his second wife
Yes,
has lost the second affair, na?
yes, my
But there she did not brought any allegation against the present informant, who is the first wife. Is there any?
Yes, Lordship. She has made allegation against only her husband.
Only her husband.
only her husband.
Lordship.
21.
Petitioner number 1 and 2 were not present on the same day, Lordship. The altercation was occurred between
Oh,
their
she lost
husband
the
and
initially
wives.
she lost the FIR first.
Yes.
Yes, Lordship. She lost
Because
the
she
affair.
lost on 21 on the day itself.
Oh, yes.
And the
Initially,
second is the second on 23rd.
21. This is the
Second FIR.
subsequently
Only
the
to-
present.
Yes, only to harass the mother-in-law family member.
Obviously, if two wives are there, then definitely
Yes.
well will
Yes.
what to do. Heard MSG Deka Dilanet for the petition, also heard Mr. P. Botaku Dilanet additional PP appearing on the state respondents, then application under section so and so entitled. Is submitted by MS Deka that the present accused petitioners are innocent. And from the FI itself, it is seen that the allegation is brought against one Safia Khatun, the second wife of the husband of Kanakali.
Second wife is petitioner's son, Lordship. Petitioner number 1 son.
কি দিলে কি বলে দিল? Sofia Khatun, who is the second wife of Kanakali লিখব নোৱাৰে। Second wife of the son of the petitioner number 1. তেনেকে লিখিলে নহ'লে নিমিলিব। She further submitted that the fact that there was a quarrel took place between two wives of one, wives of number husband. তারপরে ধরে নাও কি দিলে wife first 22 wives of one Ubaidullah, Ubaidullah, and an incident of Ubaidullah. But these two petitioners, who is the mother-in-law and relative of the present informant, is no way related in the list office. However, both the petitioners are ready and willing to appear before the IO and to cooperate in the investigation of this case if they are provided with some interim protection. Next, Mr. Waterford Ilanet additional PP submitted that CD may be called for to know the actual fact of the case. Interim. Okay, will be under interim protection. 9-4 can
9
Bless.
May I please, your lordship? My lord, the 482 application, my lord. FRA page, my lord, the relevant portion at 11, my lord. My lord, although section is 103 of BNS Act, my lord. So for the facts of the case, my lord, is that, my lord, this is and one of the accused, my lord, that is accused number 5, Orunjit Alam. They were consuming the drugs, my lord, heroin, my lord, together, my lord. And overdosing by disease has overdosed the heroin, my lord, and succumbed to death, my lord. And so far, the family members of the disease is suspected that he has killed this disease, my lord. And apart from, my lord, these facts, my lord, so far the Muhammad Arunjit Alam, who is consuming the drugs with the disease, my lord, and his wife already been arrested, my lord, they were enlarged on bail. This petitioner before your lordship, my lord, is the family members of the person who is consuming the disease, drugs with the disease, my lord. All the family members,
Petitioners
father,
are the
mother,
family members of the Olunjit Alam.
Orunjit Alam. And so far the Orunjit Alam is concerned, my lord, and his wife were arrested, my lord, and they were enlarged on bail, my lord. I have annexed a copy of the order, my lord, at page 18, my lord. After completion of the statutory period, my lord, they were enlarged on bail. Local person, my lord, they will cooperate with the investigation, my lord.
And if there is quarrel between Orunjit Alam and the deceased, who were together, why all the family members' name were mentioned in the there?
On suspect, my lord, that they were all together. This is the facts, my lord, and
he sustained injuries?
no injury has been sustained, my lord. As per my information, my lord, no injury has been sustained, my lord. And the IO during the investigation has seized some articles, my lord. As per the seizure list, my lord, I have collected the certified copy. In the seizure list, my lord, they have mentioned only that plastic vials, and it is suspected that these vials contains drugs, my lord. And second one, my lord, one BDU insulin syringe, my lord, and it is suspected that used for the pushing the drugs, my lord. These things are was seized, my lord. No arms, no ammunition, no clothes, nothing has been seized. All the family members, my lord, and so far these prime. So as per allegation, prime accused has already been enlarged on it.
Yes, but
Well, the present petitioners are accused number 1, 2, 3, and 4, 6, and 7. And accused number 5 and 8, they were granted bail
on completion of
on default bail, yes. But main allegation against accused number 2 of the present petitioner, Melo, on 10/11/25 তাৰিখৰ দিনৰ 11 বজাত মোৰ ল'ৰা জহিৰুল ইছলাম 2 নং আছামীৰ ঘৰলৈ যায় আৰু 2 নং আছামীৰ লগত টকা পইচাৰ বিবাদ হয়। উক্ত বিবাদত আছামীগণে সপৰিয়ালে মিলি মোৰ ল'ৰাটোক ঘোচা কিল গুৰ মাৰি গুৰুতৰভাৱে জখম কৰে। পিছত জখমী অৱস্থাত চিকিৎসালয়লৈ নিয়া অৱস্থাত মোৰ ল'ৰাটোৰ মৃত্যু হয়।
Then CDB call for that. When it can be fixed.
Contact name kindly be given. On 19, my lord.
It is not possible. It is saying 19.
19, my lord.
24, 24.
19 not possible.
Let it try, my lord.
No, you may try, I may try, but we cannot try.
On 20, my lord. 20. On 20, maybe. Festival is there, my lord.
They are not inside the jail, I think.
Yes, my lord. That's why, my lord. Some protection. Festival is there, my lord. That's a day we are apprehending, my lord. Let it try on 20, my lord, last day. If possible,
20, Eid may be celebrated on 20 also. I don't know.
Huh?
The probability of Eid is on 20.
On 21st, perhaps.
No, 20. 24 would be appropriate.
20. Well, let it try on 20, my lord. With all respect.
Okay.
Along with the PM report, my lord.
Yes, PM report. PM report. Yes.
20, man. Deeply obliged, man. Highly obliged.
Item.
May I please, your lordship?
Yes. Yeah, we have received the case diary.
Case diary received, my lord.
Oh.
My lord, earlier also, my lord, 36 days is in custody.
Pardon?
And
How many days?
36 days.
36 days.
And the other co-accused persons are enlarged on bail by this honorable court, lordship. I have one order, lordship. There is one and two others are enlarged in a different case on 10th, lordship. Ground was sent for 48 notice was not served, lordship. Otherwise, from the state, 3 accused persons initially arrested, my lord, and thereafter, from their statement, they stated that this is the present accused is the main person who supplied all those, my lord, fake currencies and fake gold to the other accused persons, my lord.
Is remaining.
Yes, thereafter, my lord, on being searched from the position of the present petitioner also, 200 pieces of suspected fake Indian FICN notes were recovered. Value is 1 lakh, and thereafter two boat-like structure suspected to be made of fake gold weight 1.386 kg was recovered from the present petitioner, Rustom.
Your petitioner got arrested when?
Got arrested on 6th, Lordship. Arrested on 5th, forwarded on 6th of February. He will cooperate, Lordship, local person. And he will face trial, Lordship. Co-issues are enlarged on bail, Lordship. Regarding other co-accused person, that is their statement. They try to save themselves also.
You are saying the 47 non-compliance.
48. 48.
Forwarding report page 20, my lord, same.
Page?
Page 20, my lord, page last portion, the family members of the arrested accused persons have been informed about the arrest of her telephone. However, as the family members have not appeared before the police station, a wireless telegraphic WT message has also been sent to their relative. The response upon receipt shall be communicated to the Honorable Court.
Same as the earlier forwarding report. Festive occasion is a head lordship. He has two child lordship. One is 6 months and one is 3 years lordship. That part may be considered. We will cooperate lordship and face trial.
In other two petitions, they one vehicle was parked and they were having TNL. I mean, what is your case?
My case lordship, the petitioner, the co-accused person who are arrested, they have alleged that I am the main accused person. But that is their statement before police only to save themselves.
But thereafter, on being leaded, on being searched the house of the present petitioner, from his possession, these articles were fake Indian currency note value 1 lakh and fake gold also recovered.
Four accused persons are there. Four accused persons in total are there. Three are enlarged on two different bail applications. One is before your lordship, I have forwarded, and the other bail application was 6, 7, 9. There are two accused persons. Those two accused persons are also enlarged on bail on 10th lordship of this month lordship. We can consider the end of detention and we will cooperate lordship and face trial lordship. Not even face trial lordship. On the other hand, there is lapse in serving 48 notice also lodged.
Mr. M.I. Hussain, the learned counsel, the petitioner, and also Mr. P. Waterford, the learned additional people appearing on behalf of state respondent. This is an application under section so and so in connection with so and so city receipt various district. Next, Mr. Hussain, the learned counsel for the petitioner, submitted that present petitioner is innocent and he got arrested only on the basis of statement made by the co-accused persons. However, the present petitioner is in custody since last 36 days, and hence, considering his period of detention, he may be released on bail. He further submitted that the three co-accused persons have already granted bail by this court, and considering the case of the present petitioner in the same footing, he may also be granted bail on the ground of clarity. Mr. Hussain further submitted that though there is a compliance of 47 PNSs, but there is no communication of the grounds of arrest to his family member under section 48 PNSs till date. One WT message was stated to be sent from North Lakhimpur police station to North Lakhimpur police station by Gorsuk PS, but till that the family members were not intimated about the arrest of the present petitioner, which otherwise violates the mandate of Article 22, subsection 1 and subsection 22(1) of the Constitution of India. Mr. Hussain, however, submitted that the present petitioner is still ready and willing to extend his further cooperation in the investigation of this case if he is granted with the privilege of bail. Mr. Court of Appeal and additional PP submitted in this regard that there are sufficient intimating materials against the present petitioner, who is stated to be the main culprit of this case. After coming to know about his involvement, the police also searched his house, wherefrom the fake currency notes amounting to rupees 1 lakh and two numbers of boat-shaped gold, gold-like items were also recovered from his possession. If further submitted from the forwarding report itself, it is seen that the police took all endeavor to inform the family members of the accused petitioner, and to that regard, they not only made the telephonic calls, but also provided with the 48 notice through WT message, through input PS. Mr. Court accordingly raised objection and submitted that it may not be a fit case to grant bail to the present petitioner at this stage. Next, hearing the submission made by learning counsel, without going to the further detail of the case, only considering the ground of parity and the length of detention already undergone by the accused petitioner, I find that I got sufficient opportunity to interrogate the accused petitioner, keeping him in custody, and hence further custodial interrogation may not be required for the purpose of investigation. In view of this, petitioner is hereby accordingly provided so and so to the satisfaction of CGM Kamrup. Oh,
Deeply obliged.
Lordship,
we have received this scan copy here.
yes, Lordship.
Oh, it's a very reasonable. Okay, anyway.
If your lordship will permit, can I? I just go through that quite voluminous lordship. It's only the why it has been delayed in the trial court that we have to see. Lordship will take it up after 10 minutes, Lordship. I will.
You want to go through?
I'll just flag the
Okay.
relevant parts.
Lordship, only one thing, Lordship. Lordship, on the last occasion, Lordship, only one thing is confusion in that. After last order, Lordship, of the court, Lordship, how many date was passed, Lordship? And what was the order? What was the last order? Only this thing is there left in this. I have already annexed the things in my petition copy desk, Lordship. Already I have annexed. On the last occasion.
Wait a second. I'm going to hear the matter.
Okay.
You take 10 minutes?
Yes. Yes.
Okay.
Lordship, the matter may be taken up after some time, Your Lordship. I say so to relax in other court. Person. Authorized. Made legal option. Here in this case, Lordship, I need some accommodation for today, Lordship only. Lordship may fix it Monday or Tuesday, any day, Lordship. I'm appealing today for the informal public proceeding.
My lord, here, my lord, although my lord, CD received, my lord, along with medical report, my lord, here statement is not available, my lord. Present petitioner statement, my lord. After interim, my lord, whether his statement recorded or not, that part is not available. But order copy is there, my lord. Interim order granted.
In that
that
case,
order-
Therefore, probably a
But his
copy of the
statement-
order is there.
But his statement is not available in the case.
Copy of the interim order is available in the case
I
diary.
can understand. Interim order is there, that means he appeared before
Yes.
there, but why is his statement is gone?
That is the prerogative of the IO, Lordship, whether he records or not. That probably I cannot say. Because I can only appear before him and state the
No,
fact.
your
note is
statement,
also
we
not
need your
same.
statement as to what is your stand. That
Yes.
has to be seen. That's
Lord,
why we are asking that your petition.
My stand is that they have appeared and he was questioned he was asked some questions, so accordingly he answered. But whether it is recorded or not, that probably I have to take.
There is no IO note also there, my lord, whether appearance or statement recorded, that part is also not there.
Just one thing I just want to say. Well, I have seen, say, my lord, of course, the public prosecutor will say before the court, and the case diary will reveal what is there in this case. He is a boy. Well, there is a fight between two, and what is the interim order that has been passed by this court? Kindly be seen. They said that he was injured, but on the same date he was released. On the same day. That means as if it is not a grievous, it is a simple injury and it is a fight between two parties, and accordingly he has been released on the same day. This is, he has suppressed and he has not given a true picture before the court. Because we have a research summary, my lord. My lord, we know we have got also our son. But this is not the way that one will do whatever they like it. So there has to be some control over it, my lord. My lord, please see this, my lord. See this, and this is, they could not have made that statement, my lord, before the court, and court on that, an interim bail was granted. Para 7, Para 7, kindly see the order of Para 7, my lord, of the bail. Interim bail which was granted by this court. Para 7, kindly see, my lord. Or the bail which was granted by this court. At Para 7,
Yes, I have.
this court has heard the learned counsel made by respective counsel, taking entered the facts, in the fact of release of the informants by hospital authority on this very same day. This court is of the considered opinion. That is the reason why the court considered that maybe on the very same day. But please see a research certificate. See what is the injury. And CD is there. Please see, look into it, my lord. On the very same date. And please see my discharge. How many days? See the diagnosis injury, my lord. Traumatic brain injury. And this is what they come and they submit before the court, saying that on the very same date he has been released. Same date he was released.
This submission was made.
These are very serious matter, my lord. I am no, my lord. These are students. But these are, kindly see Richard summary, my lord. Submission has been made.
Yes, this submission was made on the basis of the order of co-accused lordship that your lordship will find
Accused,
at page 21. Starts from page 21. Page 21 and relevant portion page 23. Page 23, paragraph 7, your lordship will find last 5 line. It has been further been submitted that although the accused has been booked entirely under section so and so, the victim was discharged from Apollo Hospital on the same date of his admission itself, thereby signifying that the ingredients of section 109 of BNS are not attracted
no,
in
this
the
is
case.
absolutely false.
No,
No, you have submitted.
I
It's a
have not
submission.
completed. I have not completed. Just, please one. paragraph 9, Lordship. Now, paragraph 9. On perusal of the case diary, it appears that there are prima facie materials indicating the involvement of the accused in the brutal assault on the victim, which necessitated his medical treatment at Apollo Hospital, Guwahati. At the same time, the case diary also reflects that a substantial part of the investigation has already been completed, and the statements of the material witnesses, including the informant and the victim, have been recorded. The case diary further reveals that at this stage, the investigating officer is making efforts to apprehend the other co-accused person involved in this case. So part of the case diary was reflected here, but nowhere it is said that he was not discharged. That was my submission before this honorable court. That it was nowhere mentioned that he was not discharged on the same day, because he was his submission was that part of the case diary was quoted there, and after that he was granted bail. But nowhere the court says that he was not discharged. So I do not have the copy of those documents. Otherwise, I would have annexed it and placed before the court that he was discharged on the first day, second day, third day. I would have placed. But I have submitted only from the order, Lordship, which is reflected in the order. That is what I have submitted. I have not submitted falsely that he was discharged on first day without having any basis, Lordship. That will be verified by the court from the case diary. I have prima facie submitted from the order itself, Lordship.
But order itself, he has submitted. My lord, this is on the basis on a bail application.
Yes.
And in 8/1/2026, carried to bail asset, that one of the accused, one of the co-accused who has been arrested and he was in custody, my lord. 30 days he was in custody because they could not find any clue. Unless this person, this petitioner is not being arrested, they will not find any clue who is ever, because they could not apprehend more of the accused in this case. He is a person. And he was not seen, he fled away. He fled away. Now I have been told that his father, mother has to also approach before this honorable court and the bail was granted by this honorable court. Because he was apprehending, he went here and there, could not be found. But that lead could not be found who had those other accused who was involved in this case. So what I am submitting, my lord, your lordship will definitely see the case date update. What is the statement that has been recorded? That your lordship will look into it. The statement recorded. But what I am saying, the interim bail was considered only on the ground. The court thought that it is a minor injury has taken to on the same day he was released. Kindly see my paragraph 7.
Yes,
That I understand from that reading of the order, paragraph 7, I understand that court felt that interim bail because it may be a minor injury on the same day he was discharged. And nevertheless, my lord, your lordship will a statement may be looked into what is a statement that has been recorded. His statement.
No,
Apart from
his
that, in
statement is
paragraph
not there.
Statement of his statement.
His statement is not there.
And other statement definitely will be there.
My submissions are there in paragraph 4 of that order also. That is not the only submission which I make on that day while interim order was granted, Lordship. At paragraph 4, there are other submissions were also there. That CCTV footage, the informant saying CCTV footage is there. Dear Lordship, I have categorically stated that I was not the person who hit the informant, Lordship. That can be verified from the case diary itself. There was another person who hit the person, who hit the informant's son. There also photo also I have enclosed here with. They are not saying that about that person, Lordship. That photographs are also I have enclosed. Those were submissions were also there that are reflected in paragraph 4 of that order, Lordship. And in fact, page 26, I have enclosed the person who hit the informant's son, Lordship. That can be verified from the CCTV footage also. That was also my submission, Lord. That was also
You have enclosed
considered.
photographs here.
Yes, page 26. I am not disputing that I was not present at the place of occurrence. I was present at the place of occurrence, but the person who assaulted, that is different, not me, Lord. Page 26. That can be verified from the case diary also. Because they are saying that in the FIR also they said that CCTV footage was there. So whether I have assaulted or not, that part
Yes,
can
Sharma, what do you want to submit?
Only one second. Before that, please see page 19 of the page 19. Please see page 19. His rejection, the bail order by the trial court on 22/12/2025. We start from 17 and see para 19. page 19, para 11. On perusal of the case, that it is evident there exists sufficient prima facie material supporting the allegation level against the petitioner. Accused in the FIR, the case diary includes indicate a petitioner accused brutally assaulted the victim, resulting in grievous injury that necessitated admission to so and so. Materials are reasonable apprehension if granted, the petitioner may attempt to so and so, so and so. So it indicates from the case diary by the learned trial court that there is the petitioner is involved in this case. What my learned friend said that he was not the person, but the case diary will leave it. Anyhow, my lord, this is my submission, my lord. Let the case diary be updated. His statement also, your lordship will look into it, and thereafter necessary orders can be passed, my. That's my submission, my.
My lord, as his statement is not available, my lord, she may call for up-to-date CD, my lord, from Bogista, my lord. And if there are any footage, my lord, and any link, my lord, that may also be updated, my lord.
In the meantime, Lordship, I will also file one affidavit disclosing when I went to the police station and all these things.
Not necessary. If they have appearances there.
Your order is available.
Order is
That from that aspect can be inserted. You have appeared.
If required, Lordship.
But your statement is not there.
No, my lord.
That's what I'm saying. Heard Mr. A. Amit Tilani, counsel for the petition. Petition, Tilani petition, appearing on status. And Mr. D. Das, the learned senior advocate, assisted by I. Hajarika for the informant. CD received in this case, but it is submitted by Mr. Sharma that the statement of the present petitioner is not available in the case diary. However, he submitted that the order of the interim bail granted to the present petitioner is available in the case record, but there is no note of the IO as to why the statement of the petitioner could not be recorded. In that context, Mr. Ahmed submitted that as per their information, the petitioner had already appeared before the IO and his statement is recorded. Next part, in view of above, let the updated case diary be called for, along with the statement of the present petitioner, if any, present petitioner recorded, if any, and in the event the the statement of the petitioner is not recorded by the IO, he is directed to record the statement of the petitioner within 7 days from this date of order, and the petitioner is also hereby directed to appear before the police station to that regard for recording his statement, if not recorded. What do you want to other pen drive or?
My lord, whether any, my lord, I will talk.
Okay. In view of this, CD be returned. Later, updated case diary be called for. When it can be fixed?
My lord, Provision 19. As per my 19. Then.
But he has given 7 days time, Lord.
Then obviously he'll
My
take
lord.
7 days time. So let the
Then next month, like 25th or 26th, my lord.
26 can be.
26.
It will be okay for you. 26.
My lord.
26 required. CDB return করেছে না?
Right.
Interim be extended till next day. Okay.
Obliged, Lord.
You just talk to your client also. If he has not already, if he is appeared, it is okay.
Lord.
But his statement is not available. They asked him. Then if his statement is not recorded,
As per my instruction, he already appeared, Lordship. But
that is okay. We are not disputing.
that regarding
Statement is
that
not there.
statement, Lordship, I will talk. Obliged, Lord.
Yes, Mr. Dubey, what are you submitting?
Yes, Lordship. Lordship, first of all, Lordship, in 2 years, 7 months, 12 days.
How many days? 2 years?
2 years, 7 months, 12 days, Lordship. I'm behind the bar in this case, Lordship. Lordship, in this case, Lordship, on the last occasion, when we're filing a bail application, Lordship, then it was discussed in their Lordship that due to some having the degree of the defense sites, Lordship.
Delay?
Delay for defense side, Lordship. It was delay in the trial court, Lordship. And depending upon that, Lordship, the bail petition was rejected.
No, I'm not following it. Delay in?
Yeah, delay from the defense side, Lordship. Delaying in the, that means they were not present in the trial court. That's why, Lordship, is the delay in trial. And that's why witnesses were coming and not examined in the court. But the main thing is that, Lordship, I have come to the point, Lordship, in that very, all things already discussed in the last occasion, Lordship, already discussed, and thereafter an order was passed, Lordship, on 9/12, on 11/9/2025, Lordship. Depending on that, Lordship. I'm coming to the page of that very order, Lordship, on page number 59, Lordship. The last order, Lordship. Here, Lordship, entire the things, after furnishing of the LCR, Lordship, entire the things were discussed, Lordship. And here, Lordship, on the last, that is on page number, Lordship, 64, Lordship. On page number 64, upper side, Lordship, according to the court of the learned special judge hereby directed to complete the remaining witnesses within a reasonable period and to try to dispose of the matter within a period of 6 months. That is, dispose of the matter, entire, Lordship. Now, Lordship, I'm coming to the page number, Lordship, 65, Lordship. 65%. After the rejection of that very order, Lordship, this is the last order of the trial court. That is on 17/2/2026. May I read, Lordship? Accused person S. Okim and Vijay Gupta produced with judicial custody. Today the matter is fixed for the prosecution evidence. However, no witness is present. A petitioner bearing number 41 filed on the behalf of the corporate NCB stating that Sri KB Robinson, Superintendent of NCP Gauhati, has been transferred to Itanagar, where he was joined on 16/2/2026, and as such, he will not able to be appear today, but say petition number and adjourn the said. Record reveals that so far only 4 witnesses has been examined, and the last witness was examined on 3/5/2025. The accused persons are released in jail. Issue summon to the witnesses and reason this. Trial could also feel this, Lordship, that the reason delay. Now, I am thinking that, Lordship, after the passing of dead bill reject order, Lordship, this was the direction given to the NCB. Not a single witness, Lordship, examined. This is not from our side, Lordship. And after that passing of dead body order, that is on 11/9/2025 of this Honorable Court, Lordship, on 27/10/2025, no witness. 4/12/2025, no witness. 31/12/2025, PO is on leave. 12/11/2026, no witness. 17/2/2026, that is the last order. Just I read, Lordship. Lordship, my thing is that, Lordship, in the last occasion of this present bail application also, as I was submitted, Lordship, already the matter of the LCR is discussed, Lordship. Already the new things which was, Lordship, that the order which I furnished in my petition, Lordship, that is what is the condition at present, what is the condition of the trial court. I have already submitted on the last occasion also there, Lordship. These are the date, not a single witness was examined, but the direction was given to dispose the matter. But, Lordship, what happened? Not a single witness. It is not having a matter to dispose the case, but not a single witness was examined. Now, Lordship, I am just present to the last order why it was rejected. Last occasion it was rejected, Lordship, only having it is reflected in the order, Lordship, that there is a delaying from the defense side. Defense side, they were not present in the trial court. That's why there is a delaying. As I was submitted on the last occasion, Lordship, as there is a side of the delaying from the defense side, there must be have the support has to be put some cost also. And the thing is that, Lordship, any date, Lordship, whether the witness is coming in that date, Lordship, I'm not saying that in the properly date, that witness is coming, we are not presenting in the court. On the date, Lordship, when witness are not there, Lordship, and that day we submitted petition, Lordship, because we needed time. But these all things already discussed. Now my humble submission in this court is that, Lordship, I did not have any background related to this case, Lordship. Not only from my side, my family members also there, Lordship. I am behind the bar 2 years, 7 months, 12 days till date, Lordship. After that, court is giving a direction, Lordship. And it is here the embargo of the 37, Lordship. If the court feels that, yes, there is a delay in the trial,
there is a violation of the Article 21, Lordship, then the thing which comes out here clearly shows that, Lordship, it is not having a matter that I am producing from the trial court. It is having a matter that, Lordship, court, already this honorable court given an order to dispose the things because it is delaying. And already the same things filled by the trial court also, Lordship. That's why, 17.2, this order, Lordship, clearly stated, Lordship, that the reason from the last occasion, 3/5/2025, the last witness were examined. 3/5/2025, the last witness were examined. After that, no witness come up. And again, that the persons are behind the bar. They are behind the bar. Now, Lordship, as on from my side, Lordship, I am behind the bar like this. In between of the time, Lordship, I have lost many things. I lost my father also. On the last occasion also, I given that I have lost my father. I'm not able to present my court, Lordship. Lordship, I did not have any record. My submission is that, Lordship, I did only entire of the case I'm going to the back, Lordship, only having a thing of that, yes, I have a consent that that very person is carrying drugs from the car. That's why I'm coming to the Gauhati. I was a driver. Only having these things, Lordship, only. But as I submitted, Lordship, I did not have any record with contact with the person, those who have involved in the case, contact with the dealer, contact with the supplier, nothing. In the 67 of the my submission, Lordship, in the 67 of the statement, clearly stated. Even in the co-accused of this case also, he also stated, I contact that very person, I supply this thing, I was in this smuggling from the last, I am a peddler last, this thing. But he also submitted that he is on my driver, Lordship. These are the things in the two occasions I have submitted before the court. I'm only submitted that whether I have any role, any past record, not related to the this instant case, Lordship, any cognizable offense or non-cognizable offense, any, Lordship. Now I am coming to the main fact that, Lordship, and now that, Lordship, court have given a direction to finish my grounds of this, that, Lordship. On the last occasion, it was rejected. Only I have presenting that the delay from the defense side. Now, Lordship, 5 days, not a single date, 5 days after passing the order of the honorable court, Lordship, not a single witness examined. And the trial court also feel that, yes, there is a delay, Lordship, and the person are behind the bar. And here, Lordship, that's why on the last order, because it is not having a matter of the LCR, Lordship, I have already submitted on the last occasion, the last order of the court. That's what I submitted on the occasion of that. My thing is that allowed me to, Lordship, only this is having a bail, Lordship. If I have any connection with any last case, anything, Lordship, please allow me bail, Lordship, or I'm in ground, Lordship. My only have is
Yes.
Lordship, in fact, I have gone through the I flag marked the dates on which
Yes.
it was
Yes,
there.
I'll go through, yes.
Admittedly, Lordship, the witnesses did not turn up after 3/5/25. Few dates have gone. Of course, on a few days, the PO was on leave. On that count, Lordship, I would leave to your Lordship. But so far as the materials against him are concerned, Lordship, at page 40 of the petition, there are sufficient materials against him. But on the ground of delay, I cannot overcome that. We have not been able to produce the witnesses. That is correct, Lordship. But there are materials, and your Lordship can direct the trial court to wind up the proceedings within a definite period of time, because the ratio of the judgment passed by the Supreme Court in Ashwini Upadhyay, it has to be day to day, or it has to be as fast as possible. Now, if the witnesses are not there, the court has to proceed to the next stage. That would be my humble submission, Lordship. So far as witnesses not turning up, Lordship, I cannot develop anything on that. It's on record. So,
The parents did see this here, but Mr. Andrew Petty done it counsel for the petitioner. Also heard Mr. C. Chaudhary, RKT Chaudhary did done it. You're appearing here as a
as a DSGI, Lordship, there is no
DSGI, no? DSGI, no.
Yes.
As a DSGI or standing counsel and
The there is no concept of standing counsel in the NCP.
Oh.
Previously, the
Okay,
earlier
then
DSGI used to
D-
look after.
Okay,
So
then DSGI.
it's a DSGI.
This is an application of section so and so, connection with so and so scan copy of the DCI has already been received by the DCI. Next, it is submitted by Mr. Dubey that the present petitioner is in custody since last 2 years, 7 months, 12 days. 12 days post. But till date, the prosecution could not examine the witnesses, even in spite of the direction made by this court to dispose of the trial preferably within 6 months, while rejecting the bail application for the present petitioner by its order dated 11/9/2025. 11/9/2025. You further submitted that though in the earlier bail application, the allegation also brought against the defense counsel that there was a delay in the delay in the trial, also for the fault of the defense counsel. But he submitted that on 11/9/2025, this court made an observation and directed the learned trial court below to dispose of the for conclusion of the trial, preferably within 6 months. But in spite of lapse of 5 consecutive days from the date of the earlier rejection order, the prosecution could not produce any of the witnesses till date. Mr. Dubey further submitted that on 17/2/2026, another application was filed before the learned trial court below, learned special judge, seeking bail for the present petitioner, which was rejected by the learned, bail application now, and indicate last plan to kill 17/2/2026, 17/2/2026, the learned special judge also observed that there is a delay in the proceeding, and it is also observed that on the last witness was examined on 3/5/2025, but even after the lapse of many dates, the prosecution could not examine none of the witnesses, and for which a direction was given to the prosecution for production of the witnesses positively on the next date. But we have not gone through the 26/3.
26/3, we have not arrived yet.
Yeah.
Fixed on 26/3.
No, it has to be 26/3 then. He is
Then we
submitting
can-
that, yes,
Lordship.
because a court passed a strict direction on
Yes,
17/2.
that is there.
That positively the witnesses has to be produced by 26/3.
Lordship
So
can
we have
post
not
it
gone
a
to
day or
26/3.
a day or two after 26.
Yes, yes, that has to be, I think. In that case, you give the status report.
Lordship, sure, I'll give this.
20, he said the Likok Bar, 26 kills. Last roll into. That is on 26/3/2026. Expert in that context, Mr. Chaudhary, the learned FDS, submitted that 26/3/2026 is yet to come, and hence he submitted that the matter may be refixed after 26/3/2026 to know the present status of business. In view of this, let the matter be listed on 31st. Immediately on that 31st, we are listing it on
Yes, yes.
31/3/2026, and the registry is hereby directed to procure the present status of the case record as to whether present status of the case record. Present status.
Updated status.
Oh, sorry, updated status. So the case which is pending before the learned special master. Or you can just brought
Yes.
the information also. We can
Yes, I will get that.
list accordingly on 31/3. You have submitted, but you have not pointed out that 26/3 is the next date, wherein the court had passed a strict order for production of the witnesses on 26/3. That you have not submitted. Why you have suppressed this one? Why? Why you have suppressed that the fact that the only 26/3 the next date is fixed, wherein the court passed a strict direction on 2017/2 for production of the witnesses.
On the last
You
occasion,
have submitted a lot, but you have not submitted that.
Lordship, on the today the date is fixed for the production. So today is fixed for production, Lordship.
Yeah, only for production.
Yes, on the next date, Lordship, on the last 26th, is the next.
No, I'm not saying you have while you are submitting, you have submitted many things.
Yes, Lordship.
That on 17/2 also the court observed that there is a delay in so and
Yes,
so.
Lordship.
In 5 dates, they are not coming. 3-5
Yes,
is the
yes,
last date. These things are there.
Yes,
But
Lordship.
you have not submitted that the 26th is the next date fixed by the court with a strict direction to production of the witnesses. That you have not submitted. That is you have not submitted.
Oh,
While
so-
going by the record order only,
Yes.
it has come to my knowledge that 26/3 is the next date, with a strict direction by the learned trial court below for production of the
Lordship, that's why,
witnesses.
Lordship, I'm polishing that order, Lordship. I'm reading the order, Lordship, on the last
That
order.
part you have not read out. That part you have not read out. Huh? Anyway, we are listing it on 31/3. Just after 2-3 days later on this 26/3, let's see what the learned special does did in 26/3. Definitely will pass the order. You also try to collect the order, as well as if any witnesses have been examined,
I will
we'll
put
get
it
to know from Chaudhary also.
That jewelry, my lord, your loss.
Hmm?
Earlier rejected your losses on the page 20.
You are for 38, na?
Yes, 38.
Page 20.
Page 20, yes, ma'am. Your lordship for that one. On to page 21. Well, question has come, my lord. Actually, learned PP has submitted that all the paragraph 8, my lord, just I'm coming paragraph 8.
Hmm.
Mr. Sharma learned APP raised vehement objection and submitted that he is the person who received all the stolen ornaments from the other co-accused persons. And from the case diary, it reveals that after committing the theft, the co-accused person has sold the ornaments to the present petitioner. Further, he submitted that considering the section so and so may be added, whether it is added or not, you know, my lord.
Edit.
That I have heard submission. I have also heard the case there, and it is seen that there are some differences in the article seized from the possession of the present petitioner and the ornament described in the FIR. But from the materials available in the case diary, that all the stolen recovered from the possession, that is not factually correct. Maybe your lordship, kindly see page 39. Seizure list for the present petitioners, my lord, page 39. Yeah, page photo.
Page 10.
Your
Yes.
page 39, annexure 10. Your lordship, kindly see, my lord. This seizure was from my own house. Though I am having a jeweler shop, but these things, you will kindly see the description of the articles. Golden color cargo 4 piece. Golden color earfoot 1 piece. Top 1 piece. Chain 3 numbers, but stolen only 1 number as per FIR, my lord. Golden color cargo 7 numbers. Mongol Sutra 2 numbers, but number 1 was stolen. In the FIR, only 1 Mongol Sutra was stolen. Golden color earring 8 numbers. Assamese jewelry 4 numbers. So and so, both are not mentioned in the FIR. Now, kindly page 10 FIR, my lord, the description which were stolen. Page 10, my lord. Your lordship will find after entering the house, they have stolen, nobody is named by in the FIR.
Yes.
They have stolen rupees so and so 4 lakh cash, breaking the lock of first almirah, and from second almirah rupees 60,000 cash. Some ornaments, your lordship kindly see, one number of gold necklace, one number. One number of Mongol Sutra. They recovered 2 Mongol Sutra from my house. 2 pairs of earrings. 1 number of chain. 5 numbers of gold rings. 1 diamond ring. 1 number of gold. 4 numbers of so and so from the petitioner were stolen. So all ornaments and cash amounts have been stolen and taken away. Now all these things, my lord, some were recovered from the person from the shop, jewelry shop. And co-accused matter. Well, nobody is named, so about 11 persons arrested. Out of the 6 already granted by your lordship, alone the same footing, my lord. Except only thing is what this was done from my house and others from that person, my shop. Shop. I am also having shop, my lord. But only your lordship, kindly your lordship's observation is there. It does not tell you the description, my lord. FIR and the that is ornaments received from my house, the stolen from. So recover from my house, my lord. So my case is, my lord, 47 days already, others almost all, my lord, the same footing. Your lordship, can you see your lordship's order is also there. One of Nizam and Firdaus. Page 31, your lordship. Page 31.
The same day,
And then from them also recovery was there, my page 31. They are also shop owner, my page 32. Your lordship's observation is 6. Police sees all the items from the jewelry shop and those are not even identified by the informant from so and so. This is much. And other is other. Page
Your case and the case of the others are not in the same.
Yes, my lord.
Because it is the case wherein all the accused persons have stated that after committing the theft, all the ornaments were sold to you only, not the other. And apart from that, obviously, you may have some other items also. I'm not saying that's why I have, while passing the order,
I'm not saying.
mention one thing.
You're also right
some differences.
You're also right.
Because one Mangal Sutra from your house, but though one Mangal Sutra was there.
Yes.
Harus are there in defect.
Yes.
But all these jewelry items were sold to you only, not to the other shop owner.
All my
only difference, they are not
only Caesar list. Caesar list your lordship has seen.
Yes.
These are the things we see, not all the ornaments described in the FIR are not from my house.
All the ornaments, because the Mangal Sutra, Kharus, the Kankulis, this necklace, everything is.
I am also
from your-
jewelry shop owner.
That's what I'm saying. There are difference from yours. Some
difference.
ornaments may have.
I do admit, my
but
right.
otherwise, all the items were most of the items.
I do admit, my lord. that is
there.
I am not.
Regarding the present incident,
But my only question.
The ornaments sold to the present petitioner.
Yes.
My lord, I am not disputing. I am not at all, my lord. I am disputing. That's part of your lordship correct, my lord. Rightly, your lordship has written. I am not on that. Everything is seized, my lord. Rightly, only everything is seized. 47 days, and others also, my lord. Those maybe they are on different footing, my lord. I lift your lordship, but on the consideration of the length of detention and recovery of the ornaments, my lord. Only on that, my lord. I am not on merit of that.
Okay. Yes.
Oh, no.
You are on 38.
37 minor, all the theft minor.
These are all. Oh, acha.
He is the minor, alia minor, he was the receiver of the minor ornaments minor. And present petitioners are the theft minor, who has stolen the minor ornaments and amount, cash amount 3,50,000, all undivided 95,000 they have got each. In the earlier order also it was reflected minor, they have got 95,000 each from the deputy minor.
Whom the earlier order was passed?
A lordship order is there minor.
At page 31, your lordship, in my petition.
31.
Page 30.
30, from page 31, the order starts, your lordship.
Page 32 minor. Para 7.
Yes. Yes. 95,000.
Miles. from the informant, they have stolen all the 3,50,000 and 1,50,000 from ornaments, my lord, and
Your
divided
lordship,
into
So you are
today-
again moving this petition for Khurshid Mia,
Yes,
all of
all the four, yeah,
Saifuddin,
lordship.
Duran and Asad.
Yes, your lordship. Your lordship, till today, 46 days, your lordship, whatever taken from your lordship, stolen as alleged, your lordship, already recovered, your lordship. And your lordship, considering the detention period, your lordship, I will be allowed to, the petition will be allowed to go on bail, your lordship.
In that
my
regard,
lord.
you want
My objection is already there, my lord, and that's why, my lord, from the statement of the accused, present accused persons and earlier, my lord, so Saifuddin Ahmed, it reveals they have subsequently one after another, they have taken the, my lord, more frequently they have taken the stolen articles from different theft, my lord. That is also there, my lord. And present petitioners are that they are theft, my lord. They have committed theft in different person house and sold it to the, my lord, different, that is my lord.
Now, in earlier occasion, what is your submission? In earlier case, 40, 30.
My lord, my submission was that, my lord, in earlier cases, my lord, all the witnesses and accused persons said that they have committed the theft and sold it to the, my lord.
That is okay. Yes,
That is there, my lord. And in the present regarding the, my lord, theft, my lord, they have committed.
No, in earlier many occasions also he used to receive those.
My lord, that is their statement, my lord. He has himself admitted, my lord. He himself. That's why, my lord, section added, my lord.
On that section is that.
My lord, that's why section added. That is my submission.
Your lordship,
And length of detention is not a consideration, my lord. Such type of offenses, my lord. Even they are released on bail, my lord, they will do such type of activity.
your lordship, my submission is that any condition, your lordship, I will cooperate with the investigation, your lordship. This is my humble submission, your lordship, because your lordship, till date 46 days, I'm the petition are behind the bar, your lordship. Everything has been recovered, your lordship. If something is left, your lordship, the police might have police remand may be taken again, your lordship, but that was not taken, your lordship. That's why, your lordship, maybe the petition may be allowed to go on bail, your lord.
And if 3174, my lord, then it is, my lord, 90 days.
Pardon?
My lord, 91 days offense, my lord, 317.
Yes.
Subsection, my lord. Habitually taking, my lord, theft property.
Only one thing might have disturbed in my mind. From this, all the seizure list is found that all the ornaments from this person, from every person, my lord, it is written, some items were seized. From all the person who have been already got bail and other person, my lord, that from all of them, my lord, something was recovered. Your lord, kind of seizure list, I have also annexed.
I can see.
So from
Now,
me also
they,
recovery.
They all the other co-accused persons, they are also jewelry shop owner.
Yes,
isn't
yes,
it?
ma'am.
So, but allegation against this specific allegation against you only is that
That's-
all the ornaments were sold to you.
I am not on that, my lord. I am simply saying, my lord, from all of them, some recovery was made, saying that it is stolen property. That's why your lordship also observed, it does not tell you. In my case, also your lordship already rejection order, it does not tell you. my lord. That's why something may be there, my lord. So that benefit should go to me.
Something not
That is
everything
one,
is
my
there.
lord. That's my humble submission, your lordship. And I,
Heard Mr. H.R. Chaudhary, Dilanet Senior, assisted by Mr. M. Hussain. M. Hussain, Dilanet counsel for the petition, and also heard Mr. Bishan, Dilanet petition briefly appearing on behalf of state respondent. It's an application and section so and so, inflection so and so. It is submitted by Mr. Chaudhary that the present request petition is no any such offense as alleged in the act. However, from the procedure list, it is seen that the some items have already been recovered from the possession of the present petition from his own house. And being a jewelry shop owner, being a jewelry shop owner, there is no being the jewelry shop owner, some jewelries may have some jewelries availability of the jewelry in his house. It cannot be denied. However, from the earlier rejection order passed by this court, And it is also observed by this court that there are some differences in the scissor list, which were seized from the possession of the present petitioner. There are the differences in the articles seized from the present petitioner and the description of the article made in the FIR. It further submitted that the from the if from in comparison if the articles which were seized by police is compared with the articles described in the FIR, it seems that there are differences in the items which were described in the FIR and the seizure map. Mr. Chaudhary further submitted that the accused petitioner is in custody since last 47 days and hence, considering his period of detention, also he may be released. Next paragraph. Mr. Sharma, the learned traditional people submitted in this regard that in the earlier bail application also it was observed and from the available and from the materials available in the case diary also it is seen that all the stolen items were sold to the present petitioner, and it is not the present case where he received the stolen property, but in earlier many occasions also the present petitioner used to receive the stolen property as revealed from the case diary, and for which the section 3174 ENS has already been added in the present report. Mr. Sharma accordingly raised payment objection and submitted that only considering the late detention, the present petitioner may not be released on bail. Next, hearing the submission made by Nane Council for both sides, considering the materials available in the case diary, it is seen that it reveals that the present petitioner is the habitual receiver of the stolen property, and for which the section 3174 PNS is also added against him during the investigation on the prayer made by the party. Considering the conduct of the accused petitioner and the gravity of the offense, I do not find it a big case to grant bail to the present petitioner, only considering the length of detention at this stage. In view of this, the present petition stands exposed. Stands rejected. Mr. Chaudhary, your petition stands rejected. Hard MS as learned counsel for the petition and also hard so and so for the. It is submitted by MS that the present petitioners are innocent and they have falsely implicated in this case. However, all the items were already recovered from their position and hence further custodial interrogation may not be required for the present case. Next paragraph. Mr. Sharma, the learned additional PP submitted in this regard that there are sufficient materials against the present petitioners and which have already been reflected while passing the order of earlier rejection order by this court, and he said that the probability of commission of the same kind of offense in future also cannot be denied at this stage, as they are the habitual offender who used to be a habitual offender as revealed from the case materials of the case diary. Accordingly, he submitted that only considering the length of detention, the petitioners cannot be released on bail who are the habitual offender and had committed many theft of the burglary in different in many occasions. Next, para hearing the submission made by learned counsel for both sides, the materials available in the case diary, the earlier previous criminal antecedents of the present petition, and the gravity of the offense, I find that further custodial interrogation may be required to unearth some more facts of the case. And in view of this, I do not find it a big case to extend the privilege of bail to the present petitioner at this stage, only considering the length of detention. With the above observation, the present. Your petition is also stands rejected.
Pleasure.
May I please also? Anticipatory bail application, my lord. A petitioner is not in interim, my lord. In fact, the petitioners.
He is not on.
My lord, CD not received, my lord, here.
Lordship,
I was paid for another debt, my lord.
lordship petitioners before your lordship are not a prime accused, my lord. The son
We
of
have
the
already submitted this one before earlier occasion also, I think.
lordship.
Yet one the case usually of the rape of the victim and the
One minor girl was hanged, my lord.
that a minor girl committed suicide. Na?
My lord.
Lordship. Lordship,
You are
this is
for
not
the
a
other
case
side
of murder.
appearing.
May I submit, my lord?
Hmm.
Only allegation is that there is a 7 numbers of FIR name accused, my lord, page number 14. Present petitioner are the father and mother of the main accused, and 3 and 4 is the uncles of the main accused. And
That's
petitioner,
why we have thought that
My
let the CDP peruse, they may not be
My
involved.
lord.
But
my-
that's kind of
My
nature of
lord.
offense without perusal may not
Lordship,
be.
in fact, the place of informant's house and our house is 30 kilometers away.
Your lordships. In regard to this case, my lord,
On that occasion, you have submitted one one copy of the order of the apex court also, I think.
beg your
On
pardon.
the last occasion, you have submitted one
Yes, yes, yes.
as an order of SLP and
My lord.
CS.
Apart from that, my further query is, my lord, I have also lodged an FIR. My lord, I have an instruction from my client. They did not do anything about that. That is, my lord, GD entry number 48 dated 4/6/2025. Usually, my lord, when there is a cross case, in that case, what happens? It should be proceeded by the same IO. Even the trial will also be have to be done invariably and
same.
simultaneously by the same judge. Now here, my lord, in regard to this, they did not proceed it at all. And the charge sheet, my lord, since
So in that context, have you approached the learned magistrate or the Ilaka magistrate?
no, my
as to
lord,
why-
they did not proceed at all. There is no
No, they have
investigation.
not proceeded. What was the stage on the basis of
That,
the
my lord,
GD? Why?
I'll have to get instruction.
You can approach the learned magistrate to get the instructions from
But
the
my lord,
concerned police station as to whether that has been registered or
My
not.
lord,
or
that
if not, why.
I'll tell them. But then, my lord, can your lordship, the GD entry number 48 of dated 4/6/2025, can that be called, my lord?
Is it possible?
From which police?
From which police station?
I will call for them.
From Chanmari.
No, it's my lord, the police station. Tinshukia, my lord.
Tinshukia PS itself or what?
Tinshukia Sadar.
Tinshukia Sadar.
GNT number 48.
Now, can it be called for?
I will try, Lordship, to have it.
And what is the office note? Why this scan copy is not received?
I am not looking to that, no.
11.3 note is there.
Lordship. It's 25. 25. 25.
Heard Mr. S. Dr. Dilanit Senior assisted by Mr. S. Dr. at the counsel for the petitioner, and the also heard Mr. K.K. Das Dilanit petition will be appearing on behalf of said respondent. It is submitted by Mr. Das, and also the office note reveals that the scan copy of the TCR which has been called for is not yet received. The registry is hereby directed to issue reminder with a direction to the learned trial court below to send the case record on or before the next date of listing. Further, it is submitted by Mr. Dr. Dilanit Senior Advocate that the present petitioner also laws an FIR which has been made, which is made on which a GD entry was made. Numbered GD entry number on which the GD entry number 48/2025 dated 4/6/2025 has been made under the Tinshukia Sadar police station. But as per the information, till date, no case has been registered on the basis of this ATP. In view of this, Mr. Uh, Doctor submitted that the copy of the said GD entry may also be called for on the next date of listing. In view of this, the learned additional PP is hereby asked to take necessary steps in calling the GD entry number 48 of 2025, dated 4/6/2025, made under Tinsukia Sadar. You take steps, let us see why it is there. And in the meantime, you can also approach the learned magistrate, learned Ilaka magistrate under which this case is there. Mostly CGM may be there. And to get a status report as to whether that has already been registered.
Right.
If not registered, why not registered?
Mine.
There has to be some.
I'm obliged.
When it can be fixed?
On any date for convenience.
25 or 27 will do?
27, it is fixed there also, no problem.
Oh.
Problem to 27 fixed.
After 27, will
After 10. No, do not do 30, 30, 30.
Yeah, that will. In the meantime, my lord, interim may be standard.
Yes, interim be extended till next. Okay, we are seeing.
Obliged.
Yes.
On the previous date, my lord, the State Council was asked to, my lord, seek instruction whether, my lord, FIR has been registered in this case, my lord.
Okay. Yes.
No case registered.
No case registered. We have received the report from which police station?
No case registered. My lord, case registered. Only one case registered. Sorry, Lordship. 198 of 2025.
No.
One case registered.
But in 198/2025, my lord, already NTCD bill has been granted to the petitioner, my lord.
You are already there.
I'm already there in the on.
And no other case pending on this case.
So apart from that, my lord, so
No other case. There is no other exit.
in that case, my lord, the informant was different. In 198, informant was different. I preferred NTCD bill and already
But
this.
that means what? That in the concerned police station, against the present petitioner, only one case has already been registered. That is 190. Demand number. What is the number?
Not 190. Nunmati PS case number
Nunmati PS
198
198
oblique 2025.
2025. This is registered, but recently no other case has been.
No other case.
It was
the only case.
It was the
only case
only
registered at Nunmati PS police station.
And in that case, ma'am, the order also, my lord, passed in the AB. That also.
I'll record your submission that you are already on in anticipatory.
Yes.
Mr. M. Islam, the Learned Counsel for the petition. Mr. A.K. Das, the Learned Additional AP, a report received from the concerned police station, wherein it is reported that only the Nunmati PS case number 198 of 2025 is registered against the present petition, but there is no other case is pending or registered against the present petition. In that context, Mr. Islam, the Learned Counsel for the petitioner, submitted that in the said Nunmati PS case number 198 of 2025, he already obtained the anticipatory bail and is in is anticipatory bail post. In view of this, it is seen that subsequent to Nunmati PS case number 198 of 2025, no other case has been registered in the concerned police station. In view of this, the present bail application stands closed, disposed of. However, the petitioner will be at liberty to approach the any appropriate forum in the event of registering any case against him.
But one line may be added. After interim, he stated that he has appeared.
Not interim, my lord, absolute, my lord. Absolute bail.
Oh, it is absolute.
Absolute.
No, in 198, he got the absolute bail. Absolute anticipated. That is his submission.
In fact, the my lord, AB number also may be mentioned here, 2638/2025. And order is, my lord, 22nd of January 2026, my lord. But order dated 26.
I have already recorded your submission.
22nd of January 2026 in AB number 2638. 2025.
Okay. Disposal.
Highly obliged, ma'am.
Please, Your Lordship.
Yes.
For 83
Yes, what is
application.
the 42 you have received it is there.
42 CD.
Lordship, the accused is on interim bail. Your Lordship, both, Lordship, kindly go through the FIR at page 16, Your Lordship.
Page 16.
Page 16, Your Lordship. Your Lordship, there was long-standing love affair between the petitioner and the accused persons, Your Lordship. And the allegation is that, Your Lordship, during this.
Lordship is, and my learned friend has already filed.
Produce a judgment, my lord.
Well,
In support of
therefore,
my pleadings, my lord.
if they wants to
one judgment
file,
of the-
my lord, then the matter may be fixed for other.
No, just clarify the things because two things are there. On the last occasion, on 21st of January,
yes,
it has
yes.
been observed that the IA which you have been filed
Yep.
and you have submitted also, it can be considered as a objection.
Objection.
So that may be considered at the time of hearing the
Yeah.
present petition.
In
Right.
the meantime, my lord, I will.
Now you are saying that apart from that, there may be some recent development.
Development.
So that you want to produce.
Yes.
Development in the sense, a recent development in the judgments
Judgment, my
by
lord.
the Supreme Court.
Yeah, Supreme Court.
That
So
is-
then,
I can produce it during the time of the hearing, my lord. Only citation, my lord, that is.
If my learned friend wants to or intended to file a additional affidavit, my lord, in opposition of my criminal petition, they are at liberty. Then the matter may be fixed in some other day.
Yes, that will be better.
Then
That will be better. That will be
because
better
in
if you
that
come
case,
to the record.
suppose if you submit some the judgment, also they may get an opportunity to
Yes.
furnish the copy to the other side also.
Definitely,
So
that will come to the record, my lord, also.
So
That will be
then matter may be fixed on some other day. Matter.
Last part.
Unnecessarily why at two?
Not good. Another.
No, that's why just initially just I asked him because
Which tarike I am? Agu Mahim tomorrow? No, Mahim. 23 March का है?
your convenient date.
But on 23rd and 24th I will be here, my lord. I already.
That will be better, convenient to me.
আমার পারিবনে দিব
Or otherwise April, after the.
just let me think. 23rd or 5 and 20 or both matter fixed 24th or 5. Huh?
Then after view, my lord. 20. Yeah. Oh. It will be secretary. 20 or 21st of April after view.
No,
If not possible in 23rd, 20.
March, my lord, this is convenient, my lord. This case is very, my latest judgment of the Honorable Supreme Court is said everything.
Okay, then she said that 23rd may be possible.
Mild. Interim may be continued.
Dr. Dilanit Senior assisted by Mr. S. Deca.
Yes.
S. Deca, the learned counsel for the petition. And also heard Mr. E. Botpur, No. State is also a party here.
Yes. He's a respondent.
Botpur, the learned additional. Oh, Botpur is not here. We're going to hear.
Botpur here, man.
Oh, acha.
Botpur is here.
We Botpur, the learned state person as well as you are Mr. Borwa, na?
Yes, ma'am.
D. Borwa, the learned counsel, April, but it's for number 2. It is submitted by the counsel for both sides that as per order dated 21/01/2026, the interlocutory application inter IS criminal number 1191/2025, which has been filed by the respondent, will be considered as a written objection and it can be considered at the time of hearing of the present petition. First of however, it is submitted by Mr. Borwa. There some recent development is there, and for which he may be allowed to give an additional written objection in that regard. In view of this, the matter be accordingly listed on 23rd of this month, 23rd 3/23 so enabling the respondent side to file his written objection of the additional affidavit. By 24th, you just file because it is pending.
Within a week, I will file it.
It would come at the admission column.
Yes, in admission column. That may be
Grateful, mail. Interim.
Interim was there. Interim we continue till next date of mistake.
My lord's observation.
May I please your lordship? Lordship, I am appearing as a legal aid counsel in this matter. The matter has already been, appeal is already admitted, and he has been granted bail by this by this honorable court on 31/2026. And TCR was called for in this matter. As per the office note dated 10/3/2026, it is still awaiting.
Yes, still awaited.
Still awaiting.
We are on item number 23, na?
23, no? Lordship, he has been convicted under 304 Part 2 for 7 years.
Okay. Part Mr. U. Chaudhary, the learned legal aid counsel, appearing for the appellant. Also part Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. Matter is already admitted for hearing, but it reveals from the office note dated 10/3/2026 that the TCR is still awaited. In view of this, the registry is hereby directed to take necessary steps in calling the TCR from the council court. Issue reminder, list the matter accordingly after 2 weeks as on a date to effect.
Obliged.
Lordship, LCR is come, but service answer notice.
How many respondents are there? Private respondent? One private respondent.
Well, as per instruction, she got married in another place. So
Do you know the recent address?
yes, yes. Your lordship may direct to serve notice on new address.
New address is known to you?
Yes.
Okay then. You are Mr. Burman?
Yes, yes.
Mr. N. Burman, done it for the petition. Mr. B. Sharma, done a petition. In behalf of state respondent. It is submitted by Mr. Burman that TCR has already been received. We need here the scan copy, na?
My lord.
Scan copy of the TCR has already been received. But service on the respond number 2 is still awaited.
My lord.
In view of this, again, it is further submitted by Mr. Burman that as per his information, the respond number 2 got married in another place, and accordingly he prayed to issue notice on her new place of posting. Prayer allowed, new place of residence, but present residence. In view of above, the petitioner is hereby directed to take press steps on the respond number 2 in his present and proper address. List the matter accordingly after 3 weeks you need or 2 weeks? 3 weeks. 3 weeks as an date 2 weeks. Okay, you take first step, we'll see.
Date?
You want to date? Yes, when it can be fixed? After 3 weeks, any date? Seventh of April will.
Simply obliged.
Wait, please, Your Lordship.
Yes.
Service is not complete, awaited, service is awaited.
Service is still awaited?
Awaited, still awaited. So in this matter, Lordship, the impugn order dated 27.
You have taken steps only on 21/2.
21/2.
No, you have taken steps on 21/2.
2.
Actually.
The 17, the first day, it was on 17, it was come for the considerations.
Okay. And then you took steps.
17. Then after 3 days, we'll
take steps.
Take steps.
So let the service be awaited then.
Awaited.
And in the meantime, scan copy most probably we have already received.
Yes, Lord. Scan copy PCR has been received.
Na? You are Mr. SKS Karim?
No, SRN Nasir, Lord.
SR
A.
A.
Nasir.
Nasir. Card Mr. SR A. Nasir. Is on the counsel for a petition. It is submitted by Mr. Nasir that this scan copy of the TCR has already been received, but from the note of the but from the office note dated 10/03/2026, the service is still awaited for the respondent. Let the service be awaited till next date of listing. Want any fixed date here?
Lordship, any date?
Fixed date you want?
Lordship, maybe date may be fixed, Lordship. Second.
7th of April. 7th.
7th of April.
Yes.
7th April. Lordship. Lordship, in the meantime, Lordship, impugn order may be stayed. 27/11. The stay vacating, it was stay vacating and the
Stay vacating?
I am for against the
Order of so and so.
order.
You want any interim protection? No, not.
No, I am not interim protection.
No, you want any interim order?
Yes, Lordship.
No.
Deeply aware.
Please, Your Lordship. So as per office note dated 10/3, the service report in this matter is awaited, Your Lordship. I have checked up online.
It come. Acha.
It is still in the postal process, Your Lordship.
Okay. Still awaited, no?
Still awaited. And Your Lordship, on the last date, Your Lordship had observed that the interim prayer will be considered after receipt of the scanned copy of TCR. That is also awaited, Your Lordship. So a date may be fixed, Your Lordship.
Heard Mr. G. Jad Ahmed, the land council also heard Mr. B. Sharma, the learned additional PP from the is that the scanned copy of this as well as the service on the respond number 2 is still awaited. Let the service be awaited till next date of listing, and further registry is hereby directed to issue reminder or in calling the scanned copy of the TCR from the concern. List one fixed date here?
Lordship, on 21st of April.
21st of April. 21st of
Only that observation may be there, Your Lordship. Interim.
Maybe that may be considered.
That may be again recorded.
Repeatedly, we cannot make such observation. It will be considered.
No, it was made on the last date, Your Lordship.
Yes, I know it was made the observation. Let the service be committed because similar observation, how repeatedly it can be taken up. 21/4 is it.
Lordship, in other matters, generally the court permits it. In other matters, generally the court permits. If there is an earlier observation, then that will be handled.
No, well, I'm not following you. You know, an earlier observation on the receipt of the scanned copy of
Scanned
the
copy
that may
may
be considered.
considered.
So that is still
Yeah,
continuing.
that is there.
Yes.
Yes.
What? Repeated mentioning is not required. Yes. No, 27 to 9, all 32. All 10:30. No. I got someone 27, 28, 29 to go. Same, out of same, na? Same. Or decent আপনি? Oh, 27, 28, 29, 30. What do you think? Oh,
May please, Lordship.
Both the
In
parties
this
are
case, my
for the
lord,
respondent.
against the maintenance order, only issue is that, my lord, the learned trial court without considering the SSN liability. The both parties did not file in any SSN liability.
None of the parties.
None of the parties, my lord. Only, so may I pray, my lord, in the similar circumstances, your lordship has been filed a person order, the remanding back the matter to the trial court and directed the both parties to submit the SSN liability. In the light of the same, my lord, this matter may be, if my learned friend agrees, my lord.
But you are agree by which order?
Page 27.
Page 27 and my lord, the finding, my lord, page 30. Page 30, paragraph 8. Maintenance amount has been enhanced from 2,500 to 6,000.
But your thing, your Neha Rajneesh is on which year?
2020.
2000?
Ravnesh, my lord, it was 2021 to HCC, my lord.
2021.
21 to HCC,
324.
and Tasman is 22.
No, but it was only for enhancement.
Enhancement.
You want to submit in enhancement also this applicable?
Lordship,
How?
it is a maintenance, my lord.
Maintenance in enhancement petition also it is applicable? Petition for maintenance is applicable. Okay. Rajesh Neha, it has to be assessment.
Lordship.
Through your assessment liability statement can be considered. But at the time of enhancement also, is it required? Or otherwise, if you agree, then it can be remanded.
Yes, my lord. Enhancement is because it was also for maintenance in paragraph number 72 of the
It is
judgment.
your submission.
If my lord, my
Yes, what do you want to
planet
submit?
Lordship, the petitioner is a government employee and receiving a salary monthly more than 61. After deduction, he is receiving 55,000 in the year of 2022.
55,000.
55,000. But the respondent is first wife and petitioner has another second wife, Lordship. That is discussed in the judgment. If he has another other income source, then but that was not disclosed in the evidence, Lordship. And if he has agreed by 6,000, then if the matter may be remanded to the trial court, and after filing the assessment liability, disclosing income is a government employee, Lordship, and at present it will be amount more than 70,000, Lordship. So this 6,000 is not a bigger
it
amount.
may be
and
more enhancement.
Nowadays, essential commodities is on higher side, Lordship. That is my point.
Actually, my
Only
lord,
6,000, Lordship. It is not higher amount on the.
Then yeah, you may be benefited in that regard if it is matter is remanded.
Yes, my lord.
He is earning 70,000.
Yes, my lord, he is benefited.
70,000.
More than 70.
He will benefit it. She will benefit it. Yeah, I agree, my lord. She is also a government employee and she is
No, Lordship.
Anganwadi worker. Anganwadi worker.
Regularly not received.
So
that was in
there,
Anganwadi worker are not the regular employee.
No, not
This is a contractual.
contractually. But that has to be disclosed by way of affidavit. my lord.
No, yes, obviously.
So, my lord.
Heard Mr. R. Ali, Tiranet Council.
H.A. Ahmed.
Sir? Sorry?
H.A. Ahmed.
Oh, you are H.A. Ahmed?
Lordship.
Okay. Heard Mr. H.A. Ahmed, Tiranet Council for the petitioner. So heard you are Mr.
A. Hussein.
A. Hussein, Tiranet Council for the respondent. And this is an application, section 397 of the 401, Prohibited section 482 CRPC for setting aside and quashing of the impugned final order dated 07/06/2022, passed in FC criminal miss case number 207/2001, arising out of FC criminal 207/2022, arising out of MR case number 70/2006. FC criminal miss. Submitted by Mr. Ahmed that initially, in MR case number 70 of 2006, the learned SDGM as Borpeta by its order dated 01/03/2009 directed the petitioner to pay maintenance allowance rupees 1,000 only per month to the respondent, and accordingly that was paying regularly by the present petition. Thereafter, the respondent filed another application for enhancement of the maintenance allowance under section 127 CRPC, which has been considered, and accordingly by order dated 04/08/2017, it was enhanced, the monthly maintenance was enhanced to rupees 1,500, enhanced to rupees at the rate of 1,500. That thus it was the petitioner was directed to pay maintenance at the rate of 2,500 per month to the respondent. আগতে পাঁচ বাই প্ৰিন্সিপাল জাষ্টটো লিখিব লাগিব, 5 বাই প্ৰিন্সিপাল চাই বৰপেটা, এই যে যিটো অৰ্ডাৰ আছে কষ্ট টাইটেলটো আছে তাত আছে। Next one. Thereafter, the respondent filed another application under section 127 CRPC before the learned principal just family court Borpeta, and seeking enhancement of the monthly maintenance at the rate of rupees 25,000.
Initially, it was 302, and that conviction under section 304 part 2. 10 years conviction.
And 10,000 rupees fine.
Yes, you can start.
Lordship, my most respectful submission is that there has been discrepancies in the prosecution side where the wife.
Discrepancies in the prosecution witnesses.
Yes, Lordship. But the wife of the accused, she has an important role in the case of the appellant. She had not been examined during the trial in the connection of this case. Then she's the one of vital witnesses, and that therefore it is important.
The wife of the deceased.
No, wife of the accused.
Wife of the accused.
Yes, yes, my lord. The list of witnesses there are 10 witnesses. Police witness, six police witness, 2 medical witness, then investigating officer, and 2 other witnesses. In this list, there is her name is not mentioned anywhere.
So she is not a citing witness.
The main issue was relating to her. It was a quarrel between husband and wife.
I can understand, but she is not a cited witness. But whether she is not a cited witness by the prosecution.
Yes.
Her name is not there.
Not there.
But whether any application was filed on your behalf or from the defense. For examining her as a defense witness.
Not fine. Yes, not fine. Not fine.
So she's not the cited witness. Then what?
It was a quarrel that was taking place following a marriage in her wife's friend. There was a friend, Rishima and Indira. They were friend of Mosami. Mosami is the accused wife. Her name is nowhere mentioned. Though the all altercations, all quarrel took place between the husband and the wife regarding kissing of some girl by her husband in a marriage party. But later,
Is any stay is operating? No.
Lordship, they still appearing stage, Lordship. Stay is not there.
Appearing.
No,
Appearing.
Your Lordship, the current status of the complaint case for which the petitioner has come, now that it is evidence before charge. Already evidence has been recorded there. Now the matter is fixed for charge.
Evidence before charge.
Yes, evidence before charge.
Then, but he is
I have seen-
raising the issue of cognizance, taking
Yes,
Yes.
regarding cognizance, Lordship. We challenge the cognizance
The
of.
matter has already proceeded.
procedure, but he took the
Yes.
plea
Yes,
of
Lordship.
cognizance.
Yes.
Okay, then is any convenient day for you?
Let it be after vacation, Lordship, or prior to vacation, Lordship. Next
But
month.
if is prior
No,
to vacation,
after-
then no. But if
After-
prior to vacation,
Yeah,
then
we-
charge may be charge may frame.
Election nahi jab wo election date. Your Lordship, before election, what we have before there may be there might be election date. So after Bihu it will be okay.
No, but after Bihu is okay. But the question is that as you have submitted that cases at
Yes,
present
yes.
is
Is,
pending
pending
for
of charge.
evidence
Yes.
before charge is already completed.
Now, as per the e-court service, just I have checked.
Ah.
There it is written the next date fixed on. The next date is fixed on. Last date it was 7th March 2027. It was evidence before charge that was fixed.
So if evidence before charge, that is evidence is not yet recorded.
Evidence is recorded, but charge hearing will be there.
Charge.
There are two parts. Evidence before charge is there,
Yes.
and if it is closed, then the hearing on charge will be there.
Yes. That is
So
what
you
I-
are saying that evidence before charge, that means evidence is still going on before charge.
Yes, yes.
And after that, it will be charge hearing.
Yes.
That is the case. So in that case, no, what I'm saying,
Yes.
suppose if it is come after Bihu,
Yes.
in that case, it will be more proceeded further.
Yes.
Even
Lordship.
charge may also be framed.
Yes, Lordship.
That
Because
may
since
be
no stay is there.
convenient case. That's what I'm saying.
Yeah,
Let it be on 31st of March or 30th of March.
Can it be on first week of April, Lordship? Any day first week of April.
2nd of April will do.
Yes, Lordship. It's 2nd April is a hearing day.
It's a hearing day.
Yes.
Okay, then we're fixing it on 2nd of April. Will it be convenient for you? Also, okay. Basically, you're raising the issue on technical points or what?
Yes, Lordship, because they on technical point.
Technical.
Yes. Because they are saying, Lordship, stamp paper has been obtained, blank stamp paper, signature of their side, Lordship, has been taken by this petitioner's side, Lordship. Interestingly, the search warrant was issued, Lordship. After searching, Lordship, no document was recovered from the present petitioner. That document they are try to help. They try to utilize this document to in a support of their civil case, Lordship. They have a file a civil case, Lordship. They just get support of this document to progress their case, Lordship. That is the case.
It's supporting of that document.
Yes, Lordship. Because there is no such document, Lordship. They have challenged the mutation order, Lordship. Absolutely in a civil nature, Lordship, they try to collect it as a criminal law.
But civil dispute is still going on.
Yes, Lordship. They have filed a title suit, Lordship.
What? Okay, we're listing it on 2nd. Hopefully we may.
Highly obliged.